Thank you all. Please be seated. This is a time set for oral argument in William R. Cheatham versus Sal DeCiccio. Our case numbers CV130364 and CV140135. Each side is allocated 30 minutes for argument. Appellant may reserve a portion of your time if you choose to do so. If you choose to do so, you'll need to keep track of your own time at the podium. Out of respect for counsel, I would ask those in attendance, if you have a cell phone, make sure it's turned off or in vibrate so counsel are not interrupted as they present their argument. Counsel, we have reviewed the briefs and conferenced the case this morning. We'd encourage you to keep that in mind as you present oral argument to us today. Our proceedings also are being recorded and will be posted to YouTube, so please, as you begin your argument, state your name and the party that you represent. With that, let's first hear from counsel for appellant, Mr. Napier.
Paul Orphanides, on behalf of appellants, the appellant interveners, I will also be handling the argument for appellant plea. Mr. Doran may speak a few words at the end, but otherwise I will be handling it for all appellants. And I'd like to reserve 30 minutes or 10 minutes of my time for rebuttal, Your Honor.
Very well, counsel.
For more than 37 years, ever since the City of Phoenix enacted its meet and confer ordinance, the city has relied on release time as an integral part of its efforts to improve employer-employee relations. With its meet and confer ordinance, the city sought to create an orderly, enduring framework for addressing employer-employee concerns. Release time is the city's preferred method for that framework. Release time also allows administrative investigations and disciplinary proceedings to move forward in a timely and efficient manner.
Counsel, as I read the judge's rulings below, she separated out the release time from the MOU. You know, she agreed that there may be a public purpose for the MOU, but there wasn't for the release time. The question I have is, can you do that? Can you consider release time separately from the MOU, or is it all bound together?
You can't do that, Your Honor. They're inherently intertwined. In order for the city to meet and confer with its representatives, it must have a partner to meet and confer with. So the two are inherently intertwined. If officers or any city employees, frankly, are not without release time, the city's not going to have that partner with which it can meet and confer. So it's inherently intertwined. Release time is the tool, the vehicle that the city prefers to use in order to give life to its meet and confer ordinance, in order to satisfy the purposes of the meet and confer ordinance. So release time really is an integral part of how the city how the city fulfills the requirements of its meet and confer ordinance, and release time fulfills the same public purposes that the meet and confer ordinance sought to achieve. Now, we believe that the city's or the Superior Court's ruling was marred by at least three fundamental errors. First, with respect to the issue of compensation. Second, with respect to the issue of public purpose. And third, with respect to the issue of compensation. Speaking on the compensation issue, the record was undeniably clear, crystal clear. Release time is compensation. It's part of the package of benefits that the city pays to the officers in exchange for their services as police officers.
I have trouble with that because unlike vacation time or sick leave time or other types of leave, those are individual benefits that the individual officers can invoke at the time of their choosing. Release time comes as a block. It doesn't go to the officers. The officers can't decide, oh, today I'm going to take release time, that's up to pleaded, as I understand it.
It's conceptually, it's a little bit different from vacation time, but what vacation or any of the other benefits, but what all the benefits that the officers receive share is that each and every one of those is negotiated and costed and budgeted as part of a total package of compensation. So how the city goes through its budgeting process, there will be a process by which the city and plea agree on an economic proposal, on the value of the pot. In this instance, it's $660 million for 2 years. That's the entirety of the compensation that the officers of Unit 4 receive from the city. Now, everything of that is costed out, even days off. The city's position is that the police department works 24/7. So if officers want 4th of July off, that has to be costed out. So vacation, benefits, vacation, sick leave, dental, health, insurance, all these benefits, uniform allowances, they are costed out. It's a formula, and it is all part of the same package of compensation. We had testimony from every witness in the case that release time is part of officers' compensation.
If it's compensation, how is it treated from a tax perspective?
I don't know how it's treated from a tax perspective, but just like I don't know how vacation time is treated as a tax perspective, but from a budgeting and accounting standpoint, it's treated as compensation.
From the city's perspective?
From the city's perspective and from the officer's perspective.
Well, but that would implicate the tax issue, wouldn't it?
I don't know that it would necessarily implicate a tax issue from the officer's perspective. The officers, we had testimony that the officers in effect treat release time as job insurance. It's how they make sure they have representation that they're likely going to need because complaints are frequent. In fact, they instruct you at the academy, if you're not getting complaints, you're not doing your job. Those complaints must be investigated to have those.
Maybe it's a benefit then, not actual compensation.
It is a benefit, but all benefits, compensation is a broad term. Compensation includes wages, it includes benefits, it includes release time. So it is a benefit in the sense that it is part of the package of compensation that the officers receive. We had testimony from the city's chief negotiator and from police chief negotiator that if release time is not paid to officers in release time, it will be paid to them in some other form.
Yeah, has that happened since the court entered into the preliminary or entered into the injunctions? Has the city now compensated the officers for their release time?
Yes, it did, Judge Howe. Shortly after the permanent injunction was entered by the court, the city and plea got together, as they had planned, because there was evidence in the record that they just said, well, we're going to figure out, once a permanent injunction, once a final judgment is entered, we're going to figure out what to do with release time in case it's enjoined. We're going to figure out how to recompensate the officers. They've done that now. They enacted an amendment to the memorandum where they took the remaining value of the release time that they were not allowed to use, they recosted it, and they decided that they were going to pay it to the officers in the form of additional vacation. The officers could then determine if they wanted to donate that back to police so that that could be used for releasing the officers.
And how are the duties that have been performed in release time now been performed?
It's been a struggle. There are fewer officers who are released. I think there's only 3. And they have struggled to try to provide the same degree of representation, to provide the same degree of support to the city that they were doing when they had what they considered to be the full complement of release time that they need to represent the officers and perform their obligations under the MOU. But that did occur. There was another example that is in the record. During the negotiation of the 2002-2014 MOU, the one at issue, one of the officers' priorities was removing furlough days. There had been some wage concessions and some other benefit concessions in the prior MOU, the 2010-2012 MOU. The officers wanted to restore that, and they took, in part, release time, cashed it out, redirected it to these other benefits and taking away the furlough days. So it's quintessential compensation.
Is the addendum in our record?
It is in the record. I believe Mr. Bollock submitted it in an affidavit. We reference it in the reply. I'm sure it's in the record.
Thank you, counsel.
I may have missed it, but I don't think you've stated yet that part of your point here is that if it's compensation, perhaps we don't even get to a gift clause analysis.
There is a line of cases that says that's correct. We've gone further, and we show if it is compensation, it changes the entire structure of the argument. You're looking at it from the public purpose. There's no unquestionable abuse of discretion. If you're looking at it from the consideration aspect, then you have to take into account the consideration that the officers bring to the table by agreeing to work as officers for 2 years. The city found, or the court found, that there was no consideration from plea. In our view, that was an improper analysis. We think there is ample evidence of compensate or consideration from plea.
But if we move to the consideration and disproportionality analysis for a moment, isn't the focus on plea because it is the recipient of the free services?
It is the recipient, but it's earned. Officers redirect their compensation to release time so that it can be used by plea. In our view,
it's analogous to each officer saying, I'm going to take $322 just to pick a figure of my salary and contribute it to plea. Is that what you mean?
Somewhat. I think the point is that officers' efforts have to be included in the consideration analysis. That is the consideration analysis. The two parties to the contract are the city on one side and the officers on the other. You could draw an analogy.
Plea is not a party?
Plea is not, technically, no. It's not a party to the MOU. It does have obligations under the MOU. It doesn't sign the MOU. The way the city's meet and confer ordinance is structured is that the employee unit's authorized representative has to be the name on the MOU. They have to negotiate the MOU, but the employees are the parties to the MOU. It is, in effect, their employment contract.
How do the employees speak as a unit if not through plea?
They do speak through plea. That is correct. Plea is a nonprofit Arizona corporation. And it's its own juridical entity. Its job is to represent the officers, but you could think of it as a third party beneficiary contract where one party is providing the consideration and it's directing the other party to the contract provide compensation consideration to a third party. You could also look at it like an insurance agreement. The city provides dental insurance or health insurance. The city pays those healthcare providers to provide services that to provide insurance and health and dental services that the employees earn and use. So the fact that there is this distribution doesn't change the nature of the relationship. It's still the fundamental purpose of the MOU is to outline the terms and conditions under which the employees are agreeing to work.
Counsel, if we move more formally to the issue of consideration, how should we view the issue of consideration? I understand that the judge found that there was no consideration because plea is not obligated to do anything at all under the MOU. So how do we look at what the judge did, and how should we look at the issue of consideration?
Well, we dispute that it was proper to look to plea for consideration. Our position is you should look to the officers. We also had a secondary position that the MOU does impose obligations on plea. We outlined those in our briefs. Those obligations are very similar to the obligations imposed on the union president at issue in the Wistuber case. The court found those obligations provided sufficient consideration and fulfilled a public purpose. So either way, we think there is ample consideration. There's no evidence of a gross disproportionality of consideration.
Cooper found that and correct me if I'm misstating the matter, that that the court could not consider the representation activities of plea in viewing consideration because plea was already obligated by law under the MOU, and I was kind of confused by that.
Well, we thought that was incorrect on the part of the trial judge as well. Plea has taken on multiple obligations, including the obligation to disavow any strikes, inform employees not of their obligation not to strike in the event of a strike. Plea has taken on the obligation to order employees back to work. Those are not obligations that arise under an operation of law. None of them are. They are obligations that arise under operation of the MOU. Plea puts together a complete administrative program by which officers are available. 2 standby officers are available 24 hours a day, 7 days a week for the last 37 years.
Well, as I understand it, though, that's not part of the injunction, correct?
It is an obligation that plea took on, and it is an uncompensated obligation. It is not the compensation that the judge found in that case flows to the officers who are on plea, who are on the standby. The plea does not get compensation for its efforts in organizing that program. I mean, you can imagine having 2 officers on standby 24/7 to respond to critical incidents for the last 37 years is a substantial administrative task. Plea takes that on under the MOU. That is an obligation that plea does not have under the law. Plea also has agreed that it will have an officer readily available within 1 hour's notice to respond to ordinary needs for representation. Again, that requires an administrative structure. Plea's been doing that for 37 years too. Someone has to organize that, implement it, monitor it to make sure it's happening, scheduling. These are all obligations plea takes on under the MOU. Plea also takes on obligations to participate in citywide committees, departmental committees. I mean, we pointed to a host of obligations under the MOU that arise only under the MOU, not under operation of any law or because of plea is the authorized representative. There's nothing about an authorized representative that says you have to structure a program by which you have officers available to provide representation 24 hours a day, 7 days a week for 37 years.
You're talking about the two positions under sub N?
That one, yes. There's another one, the other one that I was talking about. Well, certainly the obligations to direct employees not to strike, order them to return to work.
Make sure I was following when you were talking about the 2 people on call 24 hours a day.
Right. That was not enjoined, but that doesn't mean it's not consideration, that it's not an obligation plea takes on under the MOU. Plea is still obligated to do that.
Yes, let me ask you, Wisterber of the cases that the parties have cited seems closest factually, and the parties spend appropriate amount of time in briefs describing whether this is the same case or a different case. But then Turkin, more recently, the Supreme Court found that their prior voice, and I'll paraphrase, but may not have been one, and so that they found that the analysis in that case could only go prospectively out of fairness to the parties. That's oversimplifying what's far more elegant than that. But tell me how Turkin, from your perspective, modified the Wisterber analysis as it applies here.
I don't think it modified it so much because I think it was the cases that were decided between Wisterber and Turkin that seemed to go a bit astray in terms of the analysis that the Supreme Court thought was appropriate under the gift clause. We do think Wisterber is very analogous. We disagree about the direct application of Wisterber because of the compensation issue. We don't read Wisterber as saying that any of the release time was compensation to the teachers. And there's just nothing in the decision that indicates that it was. That was the heart of the issue. It just simply makes sense that it would have been addressed if it was. But, Turkin makes very clear the standard is an unquestionable abuse of discretion in finding a public purpose, which the Superior Court did not find. There is no reference to an unquestionable abuse of discretion anywhere in its decisions. and a gross disproportionality of consideration. The court, it ignored the ample consideration provided by the officers, and it ignored the consideration that plea provides.
Counsel, I understand that Turkin holds that the standard for reviewing public purposes, and questionable abuse of discretion because that's a political choice that
Right.
may be made. On the consideration, though, they weren't quite as deferential, at least as I read Turkin. And do we apply a different standard in reviewing consideration than we do with public purpose?
The structure of the analysis is slightly different. Turkin used the words gross disproportionality of consideration. It used the words far exceed, so if what the city is getting in return far exceed, well, the reverse. If what the party in the challenge transaction is getting far exceeds what it's giving, then there's a potential problem. So, but those are the two. I think both of those phraseologies are rooted in this concept of the trial court having to defer to the elected representatives of the people.
On both issues.
I think on both issues. I think it's a slightly different terminology in terms of.
Our cases talk about abuse of discretion just generally, not focused yet on gift clause. And then we have cases that talk about a clear abuse, and sometimes they say a clear and manifest abuse. And here we have an unquestionable abuse. What's the difference?
Well, I think it's
like two abuses, or it's two times, or it's a really bad abuse.
It's a really bad abuse. It's not a perfect analogy, but in terms of a burden of proof, it's more of beyond a reasonable doubt than a clear and convincing, or even a preponderance of the evidence. It's a much higher standard, and it's a standard that we think was not met at all here.
Counsel, let me ask you a final question from me before you can reserve, although I look to my panel mates. Turkin did talk, as you point out, gross disproportionality, far exceeds. Those are concepts that contemplate looking at two numbers. We have one number here, and the facts, of Turkin parking spaces, those can be valued. We have a case involving a hospital, that can be fairly valued. We have, riverbeds, those somehow can be valued. The issues here seem to not maybe defy value, but make value far more difficult in terms of what is received. And if you agree with that or not, how does that cut?
I think I don't agree with it, and I don't agree with it because of Wistuber. Wistuber didn't have a calculus for coming up with a number. What it comes down to is proportionality, or gross disproportionality. So it's inherently comparative. Did they prove that this was so grossly disproportionate? Regardless, I don't think you necessarily need a number. How we responded to that, the evidence in the record shows nobody disputes that the officers are underpaid. I'm sorry, overpaid. I misspoke. If the officers are not overpaid and release time is part of their consideration, how could you possibly ever have a gross disproportionality of consideration? You can't.
Counsel, and with Super, they looked at what the school district would have to do if it didn't allow the release time, and it said we have to hire a director of employee relations. So there's something that we can, that a court could look at. Here, we really don't have that.
The focus is on the gross disproportionality, and that was Wistuber was 1982. I'm not sure it makes sense anymore that a director of employee relations would be providing representation to employees or meeting and conferring.
How is the court to determine gross disproportionality? How do you measure it?
Well, two ways. The evidence is clear. There's no overpayment.
Tell me why.
The witnesses admitted that. It was unrefuted. Chief Garcia, Councilman DeCiccio, Councilman Valenzuela. The evidence in the record The unrefuted evidence of the record is that the officers are not overpaid. The other way to look at it is look at what they're challenging. Out of a $330 million contract, they're challenging $852,000. They are not challenging 99.74% of this entire contract. They don't have any problem with that. How could you possibly ever have a gross disproportionality when you're not challenging 99.74% of what's at issue?
You're saying we should be focused on the 660 million, not the 1.7 million?
Well, it's the same formula if it's either $330 million for $852,000 or six. It's a 2-year MOU. If you want to break it down by year, it's 330 and 852.
The 2-year number.
The 2-year number, that's fine. Either way, the numbers all are the same. So just to conclude, gross disproportionality, again, officers are not overpaid. They're not challenging 99.74%. How could there ever be a gross disproportionality under those circumstances? And I reserve the rest of my time for rebuttal.
Thank you, Counsel. Mr. Pollack.
Good morning, and may it please the Court, I am Clint Bolick, representing the taxpayer appellees. The gift clause enshrines in our Constitution the principle of fiduciary duty, which was recognized only recently in the Turkin decision. While on the public payroll, release time officers negotiate their own wages and benefits, solicit and prosecute grievances against their employer, encourage disobedience to the police chief's directives, lobby for their own objectives even against the city's positions, and engage in overtly political activities.
That may sound unseemly to some, but if the city likes it, what's the problem?
Well, the taxpayers don't like it, Your Honor, and of course the gift clause gives them the opportunity to challenge the abuse of discretion of the city in continuing to have this. And I should point out that the city, the record shows that the city has attempted to extricate itself from this type of deal on a couple of occasions, proposing after the first injunction a new memorandum of understanding that that basically created a bunch of public purpose activities that the union would engage in, forbidding non-public purpose activities, and establishing control for the first time. I'm
not sure. I understand what you're saying, I think, but I'm not sure that really matters here, because ultimately the city agreed to the 2012-2014 MOU.
By a resounding vote of 4 to 1.
But agreement is agreement, right?
No, it is an agreement, and of course, in our view and in the trial court's view, it was an illegal agreement. Mr. Orphanides, I think, is attempting to lead the court into a detour, basically inviting the court to detour away from the gift clause by plunging us into an analysis of whether this is compensation to the officers or a gratuity to plea. At the end of the day, Westuber teaches us that really doesn't, that it doesn't matter, that you have to look at the totality of the circumstances, and if you have a gift within an otherwise valid contract, it is still an unconstitutional gift. Nonetheless, please argument that release time is compensation is foreclosed as a matter of law. In Arizona, the only way a union may be funded is through voluntary individual contributions, which gets to a series of questions that Judge Howe was posing. In this regard, the controlling case is a case that was decided by this court in 2006, American Federation of State, County, and Municipal Employees versus City of Phoenix, dealing with a collective bargaining agreement in the City of Phoenix. It was decided, the decision was written by Judge Winthrop. And the AFSCME case speaks to this issue in two ways. First of all, as a factual matter, it happened, release time was not the central focus of that case, but nonetheless, that collective bargaining agreement contained a release time provision. And here's how the court described it, and I want to give you the pinpoint site, which is 213 Arizona Reporter at 359, 142 Pacific 3rd at 234. It described release time as, quote, providing financial assistance to the union to aid the union in acting as exclusive bargaining representative, including paying the salary of 3 full-time union officials and providing the union with another 3,610 paid hours annually. But it's the holding of AFSCME that shows why this cannot, as a matter of law, be compensation. There, the court was dealing with what was called a fair share agreement, which is even non-members of the union, as here, would have to pay a certain amount of money to the union for representing them. And the court categorically held that a city cannot legally provide a form of compensation that employees must in turn direct to the union under Article 25 of our Constitution. The city now appears to recognize that. We now, after the permanent injunction amendment was negotiated, that, by the way, just for the court's convenience, it is attached to the exhibit at IR 146, I believe. Yes, that's where it is. The amendment basically gives the police officers a form of compensation that may in turn be donated to plea. The city's reply brief here was only a single page, but it made this point very, very clearly. It said that the amendment provides officers with vacation benefits that they, quote, may then voluntarily and at their own discretion elect to transfer to plea. That is permissible. What we had in the MOU is not compensation. It cannot be compensation as a matter of law.
Councilor, on the public purpose issue, in the meet and confer ordinance, it says that the people of Phoenix have a fundamental interest in harmonious and cooperative relationships between the city government and its employees. If the city, as a political choice, decides, well, the way we want to have harmony with employees is to allow them to organize, and we'll obligate ourselves, the city, to negotiate with their representative, and we'll enter into an MOU. That looks to me like a public purpose, and we can debate the consideration issue down the road, but that looks like a public purpose to me.
Your Honor, I think the trial court emphatically declared that the MOU as a whole serves a public purpose. And you're absolutely right to identify the consideration aspect of that. I think it was, I can't remember which judge asked the question about whether Turkin had changed the law after was Stuber, and one way in which Turkin clarified the law is that there have to be tangible, direct benefits, and that would not qualify as consideration. But to get back to the main point that that you were asking, release time is a bit of an odd duck in the sense that it fails the public purpose requirement under the gift clause for 3 discrete purposes. First of all, by its very terms, it is a diversion from the public purpose.
Well, I understand your point from the briefing on that, but the city has decided that this is how we're going to achieve this public purpose. The release time can be viewed as a vehicle by which the public purpose is achieved. So if the city decides that this is a public purpose we wish to pursue, and this is how we do it, how is it a diversion? It's just a choice of how we allocate our resources to achieve our public purpose.
Well, Judge Howe, I think that with Stuber responds to your question when it says that a transaction may have surface indicia of public purpose, but we consider the reality of the transaction. And so I think that you have to look not only at the face of the contract, which itself from a public purpose perspective, we argue is disturbing, but at the reality of how release time is administered. And a second reason, there are two other reasons why it flunks the public purpose test. The second is that it's not limited to public purposes. If it were limited as it is by in the post-injunction amendment to truly public purposes, that would be quite a different matter. But we know that release time, its uses are actually completely unlimited, and the record demonstrates that release time is often used not in promotion of public purposes, but in contravention of public purposes, and Chief Garcia noted that. So I think that you give due regard to what the city is doing, but you also look at the reality of what's going on here, and release time is used and may be used. And I should mention the third thing also: no control. The appellants suggest that the Cromco decision was somewhere along the line overturned. Cromco really focuses on the essential elements of control that the city must have over city resources. And that not only is not overruled, Turkin reaffirmed it. Turkin reaffirmed it by saying that it was a core gift clause principle.
But in Turkin also said that the law court in Turkin had improperly added an element, and it reaffirmed that there are only two parts of Turkin. So if you want to look at control, where do we fit control into the analysis?
I think that control does fit within the public purposes, because you can assert public purposes, and no question about the fact that not only the contract as a whole, but Section 1-3 asserts public purposes. But if in fact there is no assurance that the conduct will comport with public purposes, then you have a failure of public purpose.
Yeah.
I'm sorry, go ahead.
You point out all of the disputes that the plea members have with the administration of the police department, but isn't that aren't those kinds of things what the city has engaged plea to do, to represent the officers in disciplinary proceedings and the like, which I guess would be adverse to the city administration. So how can you say that doing what it is supposed to be doing is against the purpose for which is engaged?
Well, it's the nature of what is being done. Can you, to use a different analogy, suppose the city engaged someone to build a bridge, and as part of the contract, every night the workers were supposed to undo what they did during the day. Even though building a bridge would unquestionably be a public purpose, unbuilding the bridge obviously would not be, but it would be part of the same contract. That's essentially what we believe, and the trial court found, and her opinion, of course, is entitled to deference, that a number of the activities that plea engages in are in fact adverse to the city's interests. And we have the testimony of Chief Garcia that says exactly that a number of the things that plea do actually detract from the mission of the police department. If that is true, it doesn't serve a public purpose. And the reason that it's true is because the city has no control over what's going on. Councilman DeCiccio probably summed it up best when he said, we don't have a clue what plea is doing on release time. If that is true, if you turn over city resources with absolutely no conditions attached to them, that on its face, would appear to violate public purpose.
Counsel, let me ask you, of the cases that the parties have cited, it seems to me that the courts typically don't go down that path. And I'm hard pressed to find a case that found something failed under the gift clause for lack of a valid public purpose or an unconstitutionally impermissible purpose. But help me understand that.
Your Honor, some of the early cases did. Proctor versus Hunt, Valley Bank, and we think, although they are oldies, they are goodies. And
I appreciate that, but I worry after Turkin exactly, what the validity or the traction of those older cases.
Well, and we acknowledge right off the bat, it is unusual to have something fail under the public purpose prong of the Constitution, but this is a highly unusual situation, and I think that Cromco is probably the closest case on point in that regard in terms of the measures of control that were found to be appropriate and adequate safeguards of public purpose there. Or you could even view that under the consideration prong. Quite frankly, it is a little tough to conceptualize this, but it's still part of the test until and unless it's overruled.
And Turkin made that clear. It's just the question
Yes.
of the vitality of that. It still's there. There's no question.
That's right. And as the Pacific Legal Foundation amicus brief noted, this is also a criterion in other gift clause cases around the country. Not that they are controlling, but it's not unusual at all to require that level of control. But here, one of the things that's also unusual about this case is we have a snapshot of life post-injunction. And if you compare the amendment that was operative afterwards, you see a city that is now attempting in good faith to comply with what the gift clause requires. And you've got sections that correspond to all of these requirements. And so you have permissible uses of union time paid by the city. But what you don't have is the open-ended, literally what is happening here is that the taxpayers have written, thanks to the city, a blank check to the union to take people who are among our most important public servants and to divert them from the purpose. These are people who are hired as police officers. They're paid as police officers. They're given the benefits of police officers, and they report to union headquarters every day. So I totally agree, Judge Thumma, that very few cases have gone in this direction, but I don't think that the courts have ever seen anything quite like this before.
Is public benefit the same as public purpose or gift clause public purpose?
Thank you, Judge Gemmell. I think that the city, in its brief, engaged in some creative editing of the test. I think that something can have no public purpose and yet yield an incidental public benefit. And I think that's exactly what's happening here. The test unquestionably is whether there's a public purpose. With regard to the consideration, in terms of the obligations, what Turkin did in clarifying, as I think Judge Thumma noted before, primarily clarified on the consideration prong, and it noted two things. First of all, you look only to what is obligated under the contract, and second of all, you look at whether the benefits are direct and obligatory rather than indirect. Now here, who should we be looking at? We should be looking at the union for two reasons. First of all, the section of the contract is rights of the association. The association being referred to is plea. In Westuber, the release time took place in the context of a collective bargaining agreement, just as it is here. Nonetheless, the court examined what the teacher was obligated to do. And as the court noted, there was a finding that they would have to replace what she was doing with a public employee if she was not doing it. Unquestionably, the holding of Westuber is that there were substantial duties and the sums expended were relatively modest. Turkin confirmed that that was the holding of Westuber, even though there is disagreement among the parties up here. The duties here are not substantial. First of all, the trial court's findings in this regard must be shown to be clearly erroneous. Very few.
Is that different than erroneous?
Getting back to the earlier discussion on that, yes, because they must be clearly erroneous.
Yeah, counsel, if you look at footnote 3 of Westuber, it provides a list of what the teacher was required to do to get the release time. And of course we're talking about teachers on the one hand and police officers on the other. But these look very similar to the items that plea is obligated to perform.
Well, Your Honor, I think that one of the things in Westuber, there was no trial, as the court makes a note of. And here there was a trial, actually 3 evidentiary hearings, and obviously plea made its best evidentiary showing, and the court concluded otherwise. But when you look, there are 3 problems with the consideration offered by plea. One is that there are very few obligations. There is a list of examples, for example, of what plea does. Of course, we know that plea does a lot of other things with public funds that may, in fact, detract from what it is supposed to be doing. Many of the benefits, like labor harmony, are indirect. And finally, and this is a very important facet of this, the court was struggling with measurement. And this was one of the things that the trial court was very, very concerned about, that the city itself, by keeping itself in ignorance about how release time was used, could not possibly make the threshold determination that there was adequate consideration here.
Is that a requirement of the gift class analysis? I saw that in Hassel, of course, but I didn't see it in Turkin.
Well, Turkin doesn't focus on it greatly, but it is helpful in the regard that when it was talking about consideration, of course, Turkin itself did not go all the way and say there wasn't consideration. It didn't decide either way. It said it would have been helpful if the city had engaged in a competitive bargaining, a competitive bidding process, because it would have yielded that type of information. It didn't say that it was a requisite, but certainly the court should give greater deference to a city that has made some type of calculation. And here, this is 180 degrees away from that, because the city has not, prior to the current amendment, has not put in place any sort of accounting system to find out how this time is used. So,
because you, at least as I read the cases, you have the burden of proving that there's no public purpose and the consideration is grossly disproportionate. So the burden is on you, but Westuber makes clear that we're not assuming disproportionality. How, and I didn't see in your brief how we can evaluate whether this is grossly disproportionate or not, and how do we deal with that?
A few responses to that very important question, Judge Howe. First of all, where one would normally think to look for this would be in the timesheets of the officers themselves, and in fact, we obtained them. And each time, and this is the bank of hours, the full-time release officers, we have their calendars. We know that they engage in political activities, but that's all we have. And their expert testified that it would be illegal for the city, or it would cause a labor problem, a labor grievance to require that they put forward these hours, which again illustrates the conflict in fiduciary duties that's going on here. But we did get the timesheets from all of the officers that were being used from the bank of hours. And what do we see on those timesheets? 2 letters, PW. That means union release time. We can't prove how the time is being used because the city doesn't require that we show how it's being used. So what do we do beyond that? Well, we find evidence of how union release time is actually being used. And in many instances, it's being used to solicit grievances and many of the other things that we talked about. How do you rate that in consideration when you actually cost the city money?
Well, the city is allowing its employees through release time to do the activities that, and I understand this is all disputed, of course, but they are allowing the officers to do what they believe is serving the public purpose, and they're being paid what their normal wage is. And whether that is for a public purpose or not, how is paying them their normal wage grossly disproportionate?
Well, we know that they are paying them their normal wage not to do police work. And I understand that gets back to the public purpose prong, but it also affects consideration. If the city thinks, is the city entitled to complete deference? And I think Judge Gemmel raised the question before, or perhaps Judge Stumma, is the consideration prong quite as deferential as the public purpose prong? I think if the city has done its homework, if the city has anything to rely on, yes, the answer is you give the city a lot of deference. But here, the taxpayers cannot know what the city has refused to know, and that is what is the value of what the police officers are doing when they are not doing police work. It is literally, again, a blank check. How much is that worth to the city? Should we defer to the city on that? No, and I think ultimately you look to the language of the contract itself, whereas the trial court found you find very, very few obligations. The main obligation is a pre-existing duty, which is a duty of representation to the officers. That is not a statutory duty. It is a pre-existing obligation. Our brief at 33 provides support for that.
Let me ask you a couple of follow-up questions. You mentioned the timesheets, and I appreciate that, but isn't the time where we need to look to see if it's grossly disproportionate at the time of the entry of the contract, as opposed to kind of a, rear view mirror look after, the contract's been put in place? Or do you think it's a moving picture?
Well, it's definitely a moving picture. And here, again, it's a fairly unusual case in which we had an injunction and the city and the union went back and pretty much did the exact same thing.
I understand that, but the issue we're asked to decide, and that was actually, I guess, the first preliminary injunction you're talking about, as opposed to the second.
Yes.
And I appreciate that. But the other question kind of comes from that is, with the exception of the Westuber case, all the other cases, it seems, deal with something that's tangible, river bottoms and hospitals and parking places that either could be traded or could be valued pretty easily on the public market. Westuber and this case seems just to be different in an order of magnitude. because it's hard to value under any circumstance what we're talking about here, in large part because from one perspective at least, it talks about government services, what governments do, and that's not typically valued
Yes.
in a way that's traded on the New York Stock Exchange. How does that cut? Who does that help here?
Well, I think by virtue of the city's self-imposed ignorance, it cuts against the city. It would be one thing if the city, and we now have an amendment in place where the city will at least know what is being done with release time. But prior to that, the MOU that is before this court right now has virtually no direct tangible obligations that are required under Turkin, and by virtue of the evidence, we know a lot of what the police officers actually do on release time. In fact, there's one type of release time that is almost entirely used for representation. All of the rest, presumably, are used for other things. So the city's failure to monitor, the city's failure to do anything, makes it impossible to defer to the city's judgment, in our view.
What if the record in this case was changed in one way, and that's the city, in entering into the MOU, said, and we acknowledge that the benefits that will be received total $1.7 million. Would your case be the same case? Because you seem to, on the one hand, you have the burden, but on the other hand, you seem to be sort of concerned that the state, or the county, or the city, pardon me, may not have kept records that allow sort of follow-up.
Well, the city's expert, or I think it was actually police expert, basically said that. And the number literally seemed to come out of thin air. I think that the city, by virtue of its fiduciary duty to the taxpayers, has to do something basically to inform its decision, to which this court would properly defer, and it has not done so.
Thank you.
Very much appreciate.
I have
I'm sorry.
two more questions,
Very well.
if you'll allow.
Didn't mean to exit prematurely.
Don't leave yet. The MOU that's before this court is the 2012-2014. Has it been replaced by an amendment?
It was replaced by an amendment, and it subsequently has been replaced with a new MOU.
That starts July 1.
Yes.
If the MOU before this court has been replaced, why are we messing with it?
Well, two reasons, Your Honor. This is clearly the type of case that is capable of repetition yet evading review. That's number one. I said two. There's actually three. Second of all, obviously it is a case of great public importance to guide other cities in what they do, even though clearly this case was identified as the most egregious example that we could find. But third, in the amendment, and I have not examined the new MOU, but in the amendment, the very last words of the amendment are very chilling to us, and that is, if any of the trial court decision gets struck down, we go back to the drawing board. So I think that even though there will not be an operative contract or amendment in a few days, this case is very much appropriately before the court.
Maybe we're not simply rendering an important advisory opinion.
That's right. You won't be wasting away your summer.
My other question is, although I would welcome you to tell us what unquestionably abused means, I'm actually more interested in your comments briefly on the fact that the trial judge did not seem to address that test, if it is the test, and it appears to be in Turkin from prior cases. She didn't address it at all, as I understand it.
Actually, Your Honor, she did.
I think she referenced abuse, but not the unquestionable abuse. And I may be wrong on that.
Well, I believe for purposes of what the court did in that regard on the public purpose prong, the substance of what she ruled meets the applicable test. She found that it was an abuse of discretion with regard to public purpose to not know how time was used or to have a system in place to evaluate the costs and benefits, and that as the city's own definition of release time indicates, release time is diversion from the public purpose, the very important public purpose of the MOU. Substantively, it satisfies the highest possible standard.
Even if she didn't use the precise word.
Exactly, Your Honor.
Thank you.
Thank you
Counsel.
very much.
Madam Bailiff, could we add 2 minutes to rebuttal time, please?
Thank you, Your Honor. Just a few quick points. The City of Phoenix plea and my client's interveners all would like to go back to using release time. So just to be clear, the elected representatives of the City of Phoenix, not Mr. Bullock's clients, who purport to speak for all taxpayers, but the elected representatives, the people who our system says gets to make policy decisions, want release time. You heard a lot of explanation about why Mr. Bullock's clients can't prove gross disproportionality of consideration. They didn't prove it. Doesn't matter why they couldn't prove it. These allegations about not having timesheets or what the timesheets aren't detailed enough or nobody knows where plea officers are, which is false, by the way, doesn't justify or excuse their failure to prove a gross disproportionality of consideration.
Well, Counsel, how can a governmental entity properly exercise its discretion, unquestionable or otherwise, without having some sort of analytical structure to judge the contracts that come before it?
Well, they do that exactly here in budgeting and negotiating the MOU. I mean, the city knows what it's going to cost. It's going to cost $660 million in 2 years. And what they're going to get a police force of 2,500 officers. They're going to have representation. They're going to have dialogue. They're going to have a partner to negotiate, to discuss, discuss employment issues as they come up. The city knows all this. They know it when they approved the MOU in 2012.
The 1.7 million is simply the cost of the general representation that the city gets in furtherance of its public purpose, and that's the number that we need to.
That's what the city.
Wait.
That's what the city is paying. The city knows what it's paying. If your question is how does the city value having officers available for standby for critical incidents, or how does the city value having administrative investigations and disciplinary proceedings move forward in an efficient basis because those officers, when they invoke their rights to representation, that representation is readily available? How does the city value sitting down and having a meet and confer process where they can address issues of employer-employee relations? I don't know how you do that, but that's their burden, and they didn't prove it. The fact that it might be difficult doesn't mean they can't. The law allows them to stop what the city wants, how the city wants to structure its employer-employee relationships. They didn't prove their case. There's been some discussion of CROMCO and control. You know, there's any number of different types of public transactions. CROMCO was really a restructuring of the University of Arizona medical system. The Board of Regents decided they wanted to have a nonprofit corporation for whatever their reasons were. They wanted to structure it as a nonprofit corporation, so they restructured it. This isn't that kind of a transaction. This is more of a fee-for-services transaction, like Turkin. Turkin was parking spaces. The city was paying $97.4 million for 3,000 parking spaces for 45 years, or however long it was. What's the control there? The city wasn't controlling what the developer was going to do with the money that it paid it, or that it was going to pay it. They're just different transactions. This control thing, I think, is a complete red herring. Gila Bend versus Walled Lake Door, same sort of situation. That wasn't a fee-for-services transaction. The city's building a water line. It's going to be the city's water line. The gift clause analysis wasn't, did they overpay the contractor by some grossly disproportionate amount, but that it was the city's water line. They were going to control the water line. So control is a red herring. This is earned compensation. The officers are redirecting. They're in fact buying release time out of their total compensation. It's just a very, very different way to structure.
Does control, or I should say, do control and measurement or data have any role in regard to the city council's discretion?
In terms of the public purpose analysis, there's no case law that says it does.
Or the assessment of proportionality?
I don't think it's necessary. Worcester it wasn't necessary. What's necessary is to prove the gross disproportionality. I mean, here I think the best proof of the lack of any gross disproportionality was all the uncontroverted testimony that the officers are not overpaid. This is officers' compensation. They're not overpaid. Where's the gross disproportionality? It doesn't exist. Control is not necessary, but there is plenty of control going on here. These officers on release time, there's two distinct categories. Officers assigned on a full-time basis to plea, officers who draw on a bank from which they're released from their patrol, whatever their duties are. The city knows where these people are. They're their employees. They can discipline them. They have been disciplined.
Can they say, I know you're assigned full-time to plea, but we have other operational demands, or that officer has particular talents, we need him over here.
Absolutely.
So that they can do that even if places know we want him here.
They can redirect. In the case of an emergency, they can redirect. They can be recalled. And there's also lots of, an officer is always a police officer. So it has always all the obligations of a police officer. Even if they're on duty and they see a felony taking place, they have obligations as an officer. It's not like they're released from being officers completely. It's being on release or using release time hours is an integral part of the way the Phoenix Police Department operates. It's not like they're being released to perform non-police functions. They're performing an integral task that is necessary for the operation of the police department. There are lots of officers work for the police department that are on administrative positions. There are even lawyers who are officers. They're not out fielding calls. There are officers that do scheduling. There are officers that do public relations. All these folks are officers. They're not all necessarily chasing down the bad guys all the time. It's a big police department with 3,000 employees, 2,500 officers. It's a lot of support, and that's what these folks do. They provide an integral task for the operation of the police department. Thank you very much.
Thank you, Counsel. Counsel, we wish to thank you all for your oral presentation, your briefs as well. There are several amicus briefs that have been provided to the court, including perhaps some authors here today, and we appreciate those as well. We will take this matter under advisement. We'll issue a written decision in due course. And thank you for your presentations today. Now, before you stand up, we do have a group of law students who are with us today, as happens from time to time. We will meet with them after we take a few-minute break here in the well. We will talk to them about a lot of things, but not this case, or any other case that we have under advisement. You are more than welcome to remain and observe if you wish. It is an open court, but if you have other things that consume your time, we'll understand that as well. So thank you. I'm bound to be photoshopped. Nice to see you.
Sometimes judges throw it low, sometimes they throw it soft. But, yeah, I think. Hey, John. How are you? Good to see you.
Hey, John. Good, how are you? Sorry, I looked in there again and didn't see you.